So by participating in the support group calls, you are acknowledging you understand there are no mental health providers or attorneys on this call, and that nothing said here is any way to be interpreted as mental health counseling or legal advice. Hello, everyone. ISNAF is grateful today to have Ashish Joshi as our guest speaker, and he will be speaking on the top 5 mistakes to avoid when litigating PA cases. And we're very thankful and grateful that he's going to be joining us this evening. So what we will have him do is he will do his presentation, and then at the end, I will ask questions. So let me introduce Ashish. I know he probably needs very little introduction, but Ashish is the owner of a law firm, Joshi Attorneys. Mr. Joshi has counseled or represented clients in state and federal courts across the United States and internationally, including in India, United Kingdom, Canada, Luxembourg, Hong Kong, British Virgin Islands, Japan, and China. Mr. Joshi has been admitted to the bar of the Supreme Court of the United States, bars of New York, Michigan, District of Columbia, and Jakarta, India. Mr. Joshi is the author of the book Litigating Parental Alienation, published by the American Bar Association in 2021. He has also published a number of articles and co-authored other books on parental alienation and child abuse. He serves as the senior editor for Litigation, the journal of the ABA's section of litigation, on the advisory board for Champion, the journal published by the National Association of Criminal Defense Lawyers, and on the board of directors of the Parental Alienation Study Group. And he's very well known amongst the PA community. And with that, Ashish, the floor is yours.
Thank you, Cindy. It's a pleasure to be here with you and your members. So I'm going to talk today about the top 5 mistakes people or lawyers make when litigating a case of parental alienation in court. And even though the talk is mainly aimed towards legal professionals, it might be helpful for targeted parents to learn about this as well as you go through the courts and the motions and the litigation process. And it's sometimes very difficult to navigate these waters. It's emotionally painful as well. It's not easy to be a targeted parent. So we'll be talking about generalities. But before we go into the substance of my talk, I want to make a disclaimer. None of what I'm about to tell you constitutes legal advice. And by that, I mean you shouldn't take my general recommendations in litigating PA cases or my observations as specifically applying to your case and run off and file a motion in the court or tell your attorney this is exactly what he or she should be doing, because every case is a unique case, and parental alienation cases heavily revolve around facts. Of course, there's science at play as well, but ultimately it boils down to the facts of your case. So please take this, what I'm about to share with you, as some general pointers that I have learned in my experience as I have litigated these cases from courts around the country in America. So a little bit about myself, as if what Cindy said wasn't enough for you, but I typically represent parents or a parent in a court of law. Sometimes I'm also appointed by the courts as a guardian ad litem. And other times I work on a case as a consultant to a targeted parent and the attorney representing a targeted parent to put together a strategy or a particular cross-examination in place and just counsel on the case. So my role differs from a case-to-case basis, depending on the time, the resources, and the place where the litigation is currently at. And I would like to share some of my observations with you today in how I see time and again, lawyers, targeted parents, even experts making the same mistakes across the country, no matter what jurisdiction, in cases involving parental alienation. So let's start with number one. It's a mistake to argue parental alienation before a judge unless you have significant evidence to support that theory. What do I mean by that? I often see parents rushing off to the court and claiming parental alienation. I often see lawyers filing motions or pleadings in the court alleging parental alienation. And when you claim parental alienation, you are essentially claiming child psychological abuse. You are telling the court that your child is rejecting you as a parent, or your child is resisting contact with you as a parent because the child is being brainwashed or programmed or influenced by the other parent. In other words, you haven't done anything to contribute to that family dynamic. And the only reason for the family dynamics dysfunction, or the only reason for the child to reject you as a parent or to resist contact with you as a parent, is because of the bad influence that the other parent has had over the child. And when you claim this, the litigation moves into a different trajectory. That litigation of parental alienation then moves on in a different way. The other side responds to that claim and makes its own arguments, and off you go to the races. And there is nothing worse in litigating a case than losing credibility with your judge. And this is the key here. Not all bad behaviors amount to alienating behaviors. There's a significant difference between a case of parental alienation and a case of, let's say, high conflict dynamics. Just because the father and the mother are unable to agree on anything doesn't make a case of alienation. Just because you have some bad behaviors from a parent, maybe even violation of court orders, doesn't make it a case of parental alienation. Even presence of alienating behaviors in a case does not, in and of itself, make it a case of parental alienation. So what is the difference here? In a case of alienation, what you do need to look for are typically the presence and confluence of 5 separate things. Some people refer to this as the 5-factor model. Other professionals or experts choose to use different other models. It's not the only model that's being used by the courts and clinicians. But generally speaking, from a 50,000 feet overview, you look at the evidence of the child rejecting a parent or resisting contact with a parent. You look for evidence of a prior positive relationship between the child and the rejected parent, the now rejected parent. You also ensure that the parent who is being rejected has not engaged in any abusive behavior, neglectful behavior, or seriously deficient parenting. You then look for signs or evidence of alienating behaviors. And there are behaviors that clinical research, scientific research, and judicial case law has identified as alienating behaviors. So you need evidence of those, because you can't just assume that alienation must be present because the child is showing some signs of alienation. And finally, you look for the symptoms in the child. The signs of alienated children are remarkably unique and different from those of children who have been estranged from a parent or who have justifiably rejected a parent or resisting contact with a parent. Together, all of this make it a case of parental alienation. So before you go to court and allege that you have a case of alienation or that your child is being alienated from you, be very careful and make sure that you have the evidence to support that theory. You don't want to argue a theory and then go in search of the facts to support your argument. You need the evidence up front, and then based on that evidence, you claim whether parental alienation exists or not. So that's number one. Stop, pause, and carefully consider the facts of your case before claiming alienation in a court of law. Number two, mistake number two that I often see is even when you do have a case of parental alienation, you don't need the ultimate relief that is reserved for the severe cases of parental alienation. Not all cases of parental alienation are alike, but we often see targeted parents and attorneys rushing to the court, claiming alienation, and asking for change of custody, specialized intervention programs that are specifically meant for severe cases of alienation, no contact order between the alienating parent and the child, reunification counseling, attorney fees, sanctions, the whole shebang. And while it's true that in severe cases of alienation, you do need all of this, or at least some of it, it's not necessarily true for a mild case of alienation. When you do have a mild case of alienation, you might be able to repair the relationship or to check the ongoing alienating behaviors by asking for and having the court order psychoeducational programs, properly devised multimodal family intervention counseling, where professionals come together and work on the entire family. The whole family dynamics are considered. So just because you do happen to have a case of alienation, pause and consider whether your case of alienation is a mild case, a moderate case, or a severe case of alienation. And the severity of alienation cases are based upon the signs shown by the children. In other words, you might have a case of a mild case of alienation, even though the alienating behaviors are pretty significant and rise to the level of being severe. Because not every case where there is significant pattern of alienating behaviors is automatically a case of severe parental alienation. In order to determine whether the case is severe or moderate or mild case of alienation, usually the clinicians or the fact finders look to the children. They observe the children, they look at the signs of the child resisting contact or rejecting the relationship with the parent. They look at how the relationship was prior to the rejection being set in, and then they make a determination as to whether the alienation present in the child is of moderate or severe quality or mild. And depending on what they find, you ask the relief to be tailored to the diagnosis or the problem at hand. So be careful. Don't rush in and ask for all of the things that we have mentioned above, because what you might do is to inadvertently scare the judge off or make the court think that this is going to be a very complex case. It's going to require experts. It's going to require a big trial, multi-day trial. It's going to require an expense of attorney fees, effort, time, and we just don't have the time for it. And that would be a shame, because mild cases of alienation can really be checked early on if you get the intervention in a timely fashion. And a timely intervention can absolutely save a case in a relationship and can protect a case from being mild into turning into a severe case of alienation. Let's talk about mistake number 3 that I often see in these cases. It's not uncommon for the alienating parent to try to create a smokescreen when alienation is alleged in a court of law. And by that, I mean that when a targeted parent walks into the court, either with an attorney or pro se unrepresented by attorney, and makes a claim of alienation, more often than not, the other side, the attorney or the alienating parent, I should say allegedly alienating parent, comes back and starts throwing several things at the court in order to create a smokescreen, create some confusion, obfuscation, anything to stonewall and detract from the real issue at hand. And you often see arguments being made about parental alienation syndrome, even though you have not alleged PAS, you or your attorney have not used that term, parental alienation syndrome. It's very common for the other side to throw that term into the court before the judge and then argue that parental alienation syndrome is junk science, it doesn't exist, it was concocted by child psychiatrist Richard Gardner, and it's a whole different controversy, and the court should be very careful in proceeding forward with this theory. And again, by doing that, not only the other side is wasting the court's time and resources, but they are doing something that is almost criminal. They are wasting precious time that is passing by during which the child and the affected parent can get proper intervention. So you would see, for example, the alienating parent come into the court and say, the other side has accused me of parental alienation syndrome. It doesn't exist, it's junk science, and I would like to have a Daubert hearing or a Fry hearing or a hearing about battle of experts before the court hears any evidence of alienation. And that, again, causes the case to move into a different arena. And the mistake that I see lawyers make time to time is to simply tell the judge, Your Honor, labels don't matter. Some people call it parental alienation. Some people call it parental alienation syndrome. I am no expert. Why don't you just have a trial and you can give it the weight that this thing deserves? In other words, let's not have a fight about admissibility and let's just hear everything, and you can give whatever weight you think is appropriate to this term, parental alienation syndrome or PA. And while that strategy may appear to be superficially smart, it's not. And here's why. You don't want to convey a message to your judge that there is indeed any controversy surrounding the phenomenon of parental alienation. You don't want to concede that parental alienation syndrome has been debunked. You don't want to send a message that there is indeed a controversy surrounding these terms and there is no general consensus amongst the scientists or researchers or mental health experts in the community on parental alienation, because that is false. Parental alienation is a scientific theory. Parental alienation has scientific underpinnings. Parental alienation has been accepted, endorsed, and acknowledged by overwhelming number of family courts across the country and internationally. So when you are telling the judge that all the arguments made by the other side about PA being a junk science and whatnot are just go to the weight of the matter and the court should give it the weight it deserves, you are somehow sending a message that there is some credibility behind that argument. And there is none. There's absolutely none. So it's your job to be abreast of the clinical and scientific literature in the field, learn it, study it, and then educate the court about it. And I'll give you two examples. Recent examples of good professional literature that have been published in scientific peer-reviewed journals. It's important to look at the scientific peer-reviewed journals and not popular media or opinion pieces where it's what people are saying is not science or peer-reviewed. The one article that came out recently is published by Dr. William Burnett and Dr. Zhu, XU, the last name. And the title of the article is Scholarly Rumors, Citation Analysis of Vast Misinformation Regarding Parental Alienation. And the article was published in December of 2022 in the journal called Behavioral Sciences and Law. And this article makes an important point that when one considers the argument about alienation from the detractors, people who claim that alienation doesn't exist or is not scientific, and you go through those articles challenging alienation, you find that the vast amount of it is misinformation. It's old, it's dated, it's based on secondary sources, and it repeats the same old misinformation again and again and again and again. And these articles that provide this misinformation and perpetuate it, they are willfully blind to the current existing research in the area of parental alienation. And if you are an attorney representing a targeted parent in litigation, and you have a case of parental alienation, you should absolutely know the current literature on alienation dynamics, estrangement dynamics, enmeshment, and child abuse. Unless you know it backwards and forwards, you can't help the court understand this, much less cross-examine an opposing expert who is going to come to the court and challenge the theory of alienation. So you have to take the time to learn the science, to learn the professional literature in this area of law and science. The second article that came out was published in the journal Developmental Psychology, again, a very reputed peer-reviewed journal published by the American Psychological Association. And this was published by Dr. Jennifer Harman and her colleagues, in all 4 authors, Richard Warshak, Demosthenes Lorandos, and Matthew Florian. And the title of the article is Developmental Psychology and the Scientific Status of Parental Alienation. And this was published in late 2022. I don't seem to have the exact month of publication here, but if you look for the Developmental Psychology Journal and this author, you'll be able to find it. If you can't, I'll be happy to send you a link to Cindy and she can publish it down the road. Why is this article important? This article is important because it demonstrates that the theory of parental alienation has strong scientific support. And it surveys the professional literature in the field of alienation across the world, not just American publications in English, but publications from other countries in other languages that have also studied alienation. But most importantly, in my opinion, in my view as a litigator, it makes a point that nearly 40% of what we know about parental alienation has been published since 2016. Not that far long ago. So when you have an opposing counsel or the opposing party who keeps on arguing about, let's say, Richard Gardner, or cites to an article that was published in 1985 or 1995, you can point out to the court that not only that so-called research is old and dated, they are being willfully blind to the current professional literature. They are being willfully blind to the current research in this field of alienation. And they are being willfully blind to the current case law coming through from all different jurisdictions to us on alienation. So don't rush and just say to your court or the judge, give it the weight you feel it appropriate. No, what you should be doing is to dismantle that fallacy, that argument that parental alienation is junk science and should not be admitted. Take it head on and make an argument upfront, educating the court about it. Let's see, mistake number 4. Before you rush in to ask for any interim relief, make sure you know what you are asking for. Let's unpack this. In cases involving alienation, it's not uncommon for the court to order some interim relief, let's say reunification counseling, or appointing a guardian ad litem. Before a trial takes place, the court sometimes wants the children to get help, the parent to get some help, put some structure in place, because trials are sometimes take time, and it may be months before you get a trial day. So when you are trying to do that, be very careful that the relief that is being asked for from the court is specified and matches the facts of your case. So, for example, if you are asking the court to conduct a forensic evaluation, make sure you are asking for what kind of forensic evaluation. Specify that. It's when I see court orders for psychological evaluation, it's just a vague label. The evaluator who is being ordered to conduct a psychological evaluation may not have a clue about the alienation dynamics. The evaluator may not have experience in that area of science or mental health issues. It's one thing to ask someone to conduct a custody evaluation. It's altogether another thing to ask someone to evaluate a case for presence or absence of alienation dynamics. It's one thing to ask the court to appoint a guardian ad litem. It's another thing to ask the court to appoint a guardian ad litem who is experienced, skilled, and knowledgeable in alienation dynamics. It's one thing to ask the court for a therapist for the children or a conjoined therapy. It's another thing to ask the court to appoint a therapist who, again, is experienced and skilled in the area of alienation dynamics. So if you are seeking interim measures, make sure that the court order is specific and clearly specifies what it is that you're trying to do as a stopgap arrangement until you get to a trial. And finally, mistake number 5, alienation cases, at least severe alienation cases, constitute child psychological maltreatment and emotional abuse, and they should be litigated as such. It's a common mistake to litigate a case involving severe alienation as if you are litigating a case involving custody or parenting time, because it's not about child custody, it's not about parenting time, it's about child protection. It's about protecting the child from the ongoing emotional and psychological abuse. So don't lose the sight of that goal. Everything else, custody, parenting time, visitation, makeup time, they all are important and valuable in its own place. But that's not what you are trying to fight for. You are trying to fight for protecting your child from the ongoing psychological abuse and to save the relationship with the child. And that should be the focus of the litigation, not custody and not parenting time. So it's very important to frame the case when you are arguing a case before the court as child protection. Yes, you may require change of custody in order to make sure that you are able to make decisions on behalf of the child for the benefit of the child. It's important to ask for more parenting time in cases of alienation as well. But that all of those are byproducts of the relief that you're seeking, which is child protection. So be careful in how you frame a case when dealing with a case involving parental alienation. And again, these are some of the top five pitfalls or mistakes that I see people and lawyers often making when litigating cases involving alienation. Alienation cases are difficult to litigate. They are very, very fact intensive. They are also very emotional to litigate. And the family courts around the country have backlog. The judges are busy. In many, many jurisdictions, there is a scarcity of judges. I mean, the dockets are so heavily loaded, and we don't have enough judges to get through these cases. And it's your job and your attorney's job to make the case simplified for the court to understand. When you adopt a kitchen sink approach and throw everything that you have in front of the judge, all you end up doing is to create more confusion and more chaos. And that prevents the court from giving you the relief that you desperately need. So simplify the case, focus on where the focus needs to be, educate the judge about the dynamics in your case, and then do your best. I think, Cindy, this would be a good time for you to follow up with any questions that you may have for your audience. I'll be happy to answer those.
Thank you, Ashish. Excellent presentation, I must say. I'm going to highly recommend to everybody that they see this and bring their attorneys with them. So a couple of things that you spoke about on the mistake number one, to argue about PA in front of the court, whether PA exists, not, then the term. What would you suggest you call it if you're not going to use the term PA? What other, let's say, dynamics, or do you show the behaviors of the children, or how would you package that for a judge?
Well, I'm never the one to be tied down with a label. In family courts, generally, the standard that controls is the best interest for the child. What's in the child's best interests? So, for example, let's say you have a parent who is consistently undermining the other parent, who is scheduling appointments, extracurricular activities, interfering with the other parent's time, all on the other parent's time, then that's a problem. You don't need to go to court and claim alienation. You can go to the court and file a motion seeking a restraining order or seeking a directive from the court that what's being done is clearly inappropriate. It's an intrusion on your parenting time. It's not co-parenting. It's, in fact, counter-parenting. It undermines the other parent's authority. It undermines the relationship the other parent has with the child. And the parent doing this should stop and ask for attorney fees and costs for having been compelled to file the motion. Now, you may not get the attorney fees and costs the very first time or second time you file this motion. But what you will do, you will educate the judge as to what's going on in your case. So if you do have to go back 9 months down the road and ask for a forensic evaluation on alienation dynamics, the judge will know by the time that you had come to the court 5 or 6 separate times previously with problems concerning the other parent's behavior. Instead of waiting until it gets to absolutely the worst possible situation and then you rush to the court, it's better to address this head on as to what behaviors are problematic and what the court can do about it.
Okay, excellent. All right. So my next question, I know you brought up the terms mild, moderate, and severe. This was on number 2 and of the mistake. And by the time parents find support, they're typically already at best moderate moving to severe, and quite often they are already in severe, and because they just don't recognize the level of severity that they have until it's already the relationship severed. ISNAF has a handbook, and per Gardner's work, which I know you've already stated is old, we determined the severity of, or we're asking parents to use his work and determine the severity by the level of contact, where the child will have contact, moderate contact, resistance of contact, and then refuses absolute contact. That would be mild, moderate, severe. So in mild and moderate cases, clearly there's other remedies. I'm going to assert from our observation, and many of our cases are in court, that the judges are already, before they'll even consider the 90-day protective order, they're making these severe cases go through, individual therapy, reunification therapy, co-parenting therapy. They go through a plethora of every single therapy evaluations before they'll even consider a protective order, no matter how severe the case arrives in their court. So what other remedies are you looking at, and can you reiterate? I know you spoke about it a little bit for mild and moderate cases.
Well, typically for mild and moderate cases, psychoeducation is one thing that judges like to consider. But the other part of the equation is more parenting time. Therapy and mental health intervention is only the part of the puzzle. The other part of the puzzle is actually what is counterintuitive. People think that, well, if the child is resisting contact with the parent, and I'm talking about the alienation cases in general, not estrangement cases. But if the child is resisting contact with the targeted parent, then we should slow down, take baby steps, make sure that the child is comfortable, and it will be a mistake to rush and have more contact ordered right away. And that's a mistake, because that's exactly what you need in a case involving alienation, because the child's perception of the targeted parent is based on the bad influence, brainwashing, programming, call it what you will, of the favored parent. And that child needs more real experiences with the parent so that the child develops the parent's image and perception based on the real experiences and not influence. So it's important to focus on the more time as well, not just the therapy or counseling part of it. But the other problem that is often seen in court is that litigants and lawyers approach the alienation cases as sometimes, zero-sum solutions or binary equation. Either it's alienation or it's estrangement. Either the other parent influenced the kid to reject this parent, or this parent must be abusive and that's why the kid is rejecting the parent. And it's not always so simple. In many cases, you see somewhat of a hybrid situation where one parent is being alienating or gatekeeping behaviors, and the other parent being anxious about it and seeing the child reject them, lashes out and reacts poorly, and you see the parent who's being rejected engage in some questionable parenting behaviors, sending out angry text messages. If the child doesn't call as per the time, let's say there's a call scheduled for 9 p.m. every evening, the parent starts calling nonstop, sending text messages. Why haven't you called? I deserve a call. I'm your father or mother. You don't get to treat me this way, lashing out on social media. So that reaction to the rejection by the child or the reaction to some alienating behavior is so poor that it ends up making the case far worse than it was. And that's what professionals sometimes miss on. And they conflate and confuse the reaction with causation. Instead of looking at the relationship of what it was, let's say 6 months ago, before alienation set in, and how was that rejected parent behaving at that point in time, they look at the dynamic now, and then they conjecture or speculate that the child must be rejecting this parent because of the parent's anxiety or anger or frustration. And it's not so easy in a court of law for a judge to just get this based upon the court filings, because a judge looks at their one party's allegations of alienation, pictures, photographs, whatnot. The other party comes in with an affidavit from a child's therapist, for example, or guardian ad litem saying the child's really traumatized. So the court's not gonna make quick decisions without holding an evidentiary hearing. The judges have to hold a hearing to make findings of fact. And what they're looking to do in the meantime is to appoint a good professional, like a guardian ad litem sometimes, or appoint a good therapist in the case for joint therapy that will hopefully settle the case, hopefully bring the parents to the table together to work on a solution. But if not, will not make the case worse than it already is until the trial rolls around. That's what they're trying to do.
Okay. Thank you for that answer. So in that answer, you mentioned where the parents have reactions, and so it becomes a hybrid case.
No. Let me go back. Let me make sure this is clear, because this is a very important point, Cindy. A targeted parent's reaction to alienation does not make an alienation case a hybrid case. A hybrid case is a case where parent A, the favored parent, has engaged in alienating behaviors. Those behaviors have affected the child into rejecting the parent B or resisting contact with parent B. However, parent B in the past has also engaged in some questionable parenting decisions, may have engaged in some abusive behavior, neglectful behavior, may have had issues such as alcoholism, may have been an absentee parent, but now realizes that they need to step up and do the parenting, whatever reason. But there is some legitimate reason for the child to resist contact with parent B. And together, those factors make it a hybrid case. Compare that situation with a case where parent A has engaged in alienating behaviors that have affected the child to reject parent B. And after that rejection set in, parent B, because of being frustrated, angry, afraid about getting rejected from the child, is now starting to lash out. That is not a hybrid case. There is a case of alienation with the targeted parent behaving in a poor fashion, but still a very much a case of alienation. That targeted parent needs coaching, no doubt. They need some support in terms of therapy, counseling, coaching, to not make an alienation case worse than it already is. But that's not a hybrid case.
Thank you for that clarification. I can't tell you how long I have been working with professionals to get finer clarification. So that clarification brings to mind another question then. On the, now I understand that the targeted parent has had this bad, I'm going to say, for lack of a better word, bad behavior or questionable parenting, okay, prior to the alienation happening, correct? So what is an estrangement case? It was my understanding that estrangement was that bad behavior prior, causing the child to be estranged from the parent.
That's true. Estrangement cases are cases where the child has the legitimate reason to reject a parent or to resist a relationship with the parent. So, for example, in a case involving, let's say, a couple divorcing, the child is resisting the father because the father has always been a strict disciplinarian and has engaged in physical corporal punishment. The father, for example, let's say, has engaged in beating the child up using a belt or a switch, engages in severe physical discipline that could be seen as abuse by the protective services. And the child is now growing up and now finds the mother's parenting style to be nurturing and completely in contrast with that of the father. And those kind of parenting decisions or those kind of parenting behaviors could seen as a case involving estrangement. Or let's have a case where the child is resisting contact with the mother because the mother was an alcoholic. The mother had severe problems with alcohol. The child has seen the mother intoxicated on a repeated basis, lash out in violence to the child and the siblings or the father under the effects of alcohol. But the mother went to the rehab, got clean, and is now wants to rebuild the relationship with the child still resisting contact because of the previous perceptions of the mother. That's a case of estrangement. In both those cases, the assumption is that the other parent is not undermining the role of the parent who is being rejected. The other parent is not exaggerating the flaws of the parent who's being rejected. The other parent is not sabotaging the relationship between the parent who's being rejected and the child, but it's the parent's own conduct which is causing the child to reject them or to resist contact against them.
Excellent. Thank you. I'm so grateful we have that in a recording. Our parents and our attorneys will benefit from that greatly. So my next question, and I really appreciated you getting so much into 5 mistakes. I only have 2 more questions. The next question that I have is you spoke about the alienating parent creating a smokescreen, and which is basically delaying time. And we see this a lot with teenage children, only so that they age out. And then by the time they're 14, it's even more difficult for the judges to get the proper remedies, and the children refuse to cooperate and so forth. So what can a parent do when you have the other parent coming in creating the smoke screens? What are the, what is the action that they need to be taking?
Depends on what the smoke screen is about. So my personal preference is that when I see a motion filed by the other side saying that parental alienation syndrome is junk science, or parental alienation doesn't have scientific consensus or scientific underpinning about it, I don't rush in and tell the court, Your Honor, this all goes to the weight. You can give it whatever weight you deserve in the trial. I take that opportunity to point out all of those fallacies. And sometimes it gets interesting because I've been able to show that the lawyer who is now claiming that parental alienation is junk science, not too long ago, the same lawyer was representing an alienated parent and was arguing the exact opposite. 6 months ago, that lawyer was claiming that parental alienation is child abuse. Parental alienation needs to be acted upon immediately. And when you show that to the court, that party loses credibility. I can tell you the judges are not happy about this. You can also show to the court some good science in prestigious journals like Journal of American Academy of Child Psychiatry, Behavioral Sciences and the Law, and some good reputed books that have come through, some professionals as well. But more importantly, you can show the court that case law in that jurisdiction. Let's say you have a case in New Jersey or New York. You show the court number of judicial decisions in New Jersey or New York where the courts have found alienation, where the courts have endorsed and accepted the theory of alienation, where the courts have provided intervention. Could it be change of custody, more parenting time, mental health intervention, whatever? But the idea is to show to the court that this particular judge is not being asked to reinvent the wheel here. These decisions have been taken by other judges in similar circumstances, and the court can rely on them. And then it depends and boils down to that particular judge as to what he or she wants to do. But the time to educate the judge is at that point in time, and to give the court the tools that it needs to make the appropriate decision. Because sometimes it can get really confusing for a family court judge, particularly a judge who is not that experienced in high conflict cases, alienation cases, because they see that as a battle of expert. I have two experts coming in, both PhDs, one saying there is no such thing as parental alienation, others saying parental alienation not only exists, but it's child abuse. What am I to do here? And that's where you try to explain to the court that not all articles are equal. There is a difference between an article published in a scientific peer-reviewed journal versus an opinion piece published in a non-peer-reviewed journal. And you can look at the established case law. In almost every jurisdiction in this country, there are cases where the courts have wrestled with the problem of alienation and have come through, found alienation, acknowledged it, and provided the right intervention. Even the cases where the courts have refused to find alienation, they're not challenging the phenomenon. Rather, what the courts are saying is that in this particular case, we refuse to find alienation because of these reasons. And it's important to show those decisions to the court. One other thing that I like to do, or I prefer doing, I don't necessarily restrain myself to a particular jurisdiction. So to give you an example, let's say I'm litigating a case in Florida, and I happen to find an excellent court decision with much of the similar facts that are involved in the Florida case, but the decision happens to be out of, let's say, the state of Washington in the Seattle area. I use the decision. Of course, the decision from Seattle is not binding on the judge in Florida. But what you are trying to show to that judge is here's another judge in a different part of the country that has wrestled with very same or similar situation that you are handling, took the time to write this detailed opinion, and I would like you to consider it. It's not binding on you. Maybe it will help you, maybe it won't. But what's the harm in looking at the facts and the law and the science that this particular judge considered? And lawyers often just get very compartmentalized, and they ignore cases from the rest of the jurisdictions and just focus on their jurisdiction. And I think it's a mistake to think in that way when you're dealing with cases that are intensive in science.
Excellent. Good for our parents to know that. My last question is, you speak on your mistake number 5 on that it's psychological abuse for the child. How do you actually prove that to the court?
There are a great number of research studies that have shown that children who go through adverse experiences during their childhood, they're called ACE studies, for example, have long-lasting physiological and psychological effects. There are studies that have shown that child psychological maltreatment is as harmful, if not more, in some cases, as physical or sexual abuse. Then there's a whole different material from American Professional Society on abuse of children. They don't use the word alienation. In fact, they caution professionals to be careful before using the term parental alienation or parental alienation syndrome. But nevertheless, when you look at the behaviors that they consider to be child psychological maltreatment, they call it adultification, parentification, infantilization. But you look at the underlying acts or the behaviors they're complaining about, and they are very, very similar, if not identical, to the things that alienation proponents talk about. So there's a lot of research out there, but at the end of the day, what you are hoping for is a clinical or a judicial finding of alienation. So at some point in time, you need the court to either appoint a forensic professional to do a custody evaluation or a forensic evaluation or a psychological evaluation and make clinical findings, which can be adopted by the court in a trial and converted into judicial findings. Or if you don't have the time to do that and the child risks aging out, you ask for an evidentiary hearing and put whatever evidence of alienation you have in front of the court and let the judge make a finding of fact. It's not, you don't have the luxury in every case to ask for a forensic evaluation because that takes time, sometimes months. And in some cases, it may be better to just go through an evidentiary hearing and let the judge connect the dots for you.
Okay, excellent. So I have one last question. I know I said that was going to be the last question. And that is, if parental alienation is not in the DSM, how can the judge get a finding on it? And how can you prove that? Is it done through experts?
Yes, the judges are expert fact finders. In fact, there's a great case from Canada that came out in 2019 from Ontario Court of Appeals, where the Canadian Appellate Court said that we are taking judicial notice of the phenomenon of parental alienation, that it's real, it exists, and when it does exist, it causes harm to the child and the relationship the child has with the rejected parent. There are also decisions which have held that you don't need an expert in a court of law to find alienation. A trial judge could make findings of fact. Judges make findings of fact in all situations. When a parent is behaving inappropriately, when a parent is an alcoholic, when a parent has drug or substance abuse issues, when the parent is behaving in an abusive manner, they look at the behaviors and they determine whether those behaviors are harmful to the child's welfare, or the child's well-being, or the child's relationship with the other parent. Alienation is not rocket science. The judges could see the same behaviors and make the determination in a case involving alienation. But going back to DSM-5, it's a mistake to say that parental alienation is not in DSM-5. It certainly is. The concept of parental alienation is very much contained in DSM-5 under 3 separate diagnoses. And the umbrella under which it's covered is called child affected by parental relationship disorder, CAPRD. And Dr. Burnett and Dr. Greenhill, I believe, wrote an article on precisely this topic that was published in 2016 in the American Journal of Child Adolescent Psychiatry, pointing out how DSM-5 very much contains a concept of parental alienation. So you don't need to have the DSM-5 use the exact label parental alienation in order to claim that these behaviors are very harmful and should be checked by the court.
Excellent. Thank you for that. Now I have to ask one last one, I promise. Have
I hold
you,
you to that.
okay, have you ever represented a case using coercive control and been effective with that?
In you mean in alienation situation?
Correct.
Oh yeah, absolutely. I mean, the coercive control uses the same dynamics that alienation cases do. And Dr. Harmon, Jennifer Harmon, has written about it. And it's all included in the under the umbrella of family violence, because the power and control wheel that domestic violence advocates use, you see the same behaviors of exercising power and control in cases involving coercive control, in cases involving parental alienation as well. And it all comes together. These are the same pathological behaviors we are talking about. They are all about power. They're all about control. They're all about completely eviscerating the child's relationship with the other parent because of hatred, animosity, enmeshment, and all of it. It's all interconnected for sure.
Okay, excellent. Well, I know our time is up, but I want to thank you for the wealth of knowledge you've departed upon us in this short period of time. And I know you're going to get lots of people online. We're going to be sending everybody with their attorneys and their mental health providers to be watching this YouTube once we get it posted. So thank you again. I wish you a wonderful week, and I'll look forward to seeing you sometime soon in the future. And you're always welcome to come back and present for ISNAF. You're, a wealth of knowledge. So with that, thank you very much.